and richly privileged to address you on certain aspects of the matter, which we, the lawyers, are doing for every day. But on the administrative side, sometimes you may not be dealing with every day only, but only when problem arises. So, I am the first day today to address the question or address the concept of reservation, its impact, how it works out in practical regime. This is the three issues which I am posed today to address you for a short address. What is reservation is the first question. The reservation is founded separating individuals or group of persons having certain characteristics from the general candidates and conferring them a special benefit on them. To put it otherwise, it is a discrimination in favor of backward class communities or persons or classes of persons. A discrimination shown in favor of a particular group of persons is called as reservation. Reservation takes in different forms. One is generally known as compensatory discrimination. Compensatory discrimination is granting a favor in favor of a group of persons who otherwise suffer socially, economically, or educationally backwardness for years together, or persons who are not able to compete with other groups of persons and in their favor. That is, a persons who are discriminated or who cannot compete in the race. Generally we call it a race is conducted. A race between a racehorse and a crippled horse. Give them equal chance. We'll say you are given equal chance, you run 2 kilometers. But a crippled horse is concerned and a racehorse is concerned. The concept of equality is not there because a benefit, additional benefit, a compensatory benefit, a compensatory concession is to be granted in favor of crippled horse to compete with a racehorse to make the concept of equality a reality. So we call it a compensatory discrimination. We generally call it discrimination because persons who suffer for centuries or years because of their social, economic, and educational backwardness, they should be given equal opportunity, come up in the society, to compete with other persons. So a discrimination, a favored treatment is shown in their favor. Or we will call it otherwise, this is a reverse discrimination. Reverse discrimination is against the person because equality before law and equal opportunity of law, equal before law, is the concept or cherished concept. Equality should be there, all are equal. But a discrimination is shown, a reverse discrimination is shown in favor of persons who cannot compete or who suffered a lot or who cannot come up to the extent of the expected level of achievement. Maybe, as I submitted the concept, educationally, economically or socially. Then others. And it is also called a protective discrimination. To protect certain persons by granting them a favor, a reservation. So, reservation in favor of the persons, group of persons, class of persons who are discriminated for years together, who could not come up, who could not compete, who are not treated equal with others because of their backwardness in all aspects of life, then we grant, Constitution protects them in granting a compensatory discrimination or a reverse discrimination or a protective discrimination. So the historical background of reservation is the inequality prevailed in Indian society for years together. Because you know, earlier it's a historical fact, now it's not reality, and shall not be a reality at all, and stability, and because there were certain persons are totally discriminated from attending the educational institutions or acquiring a qualification or the classification based on their job, etc., vocation, etc., classification based on that, religion and other things, etc. These persons should be brought into the mainstream so that they can compete equally with others who are enjoying a privilege not otherwise granted to them by the Constitution or by the society, but they are enjoying it because of the reservations, because of the social, economic situation prevailing. We say the Constitution provides, Article 14 of the Constitution provides reservation. Reservation is provided for socially and economically or educationally backward persons. How it is practically implemented? The social backwardness is protected or equality is maintained by making reservation in favor of certain persons belonging to a particular community or even for that matter a religion, to bring them up to that of the other community, forward communities. Then we call that they are given the protection granted and also educate socially backward persons, where socially or backward community in relation to education. Education also, as I said earlier, a group of persons are getting better education, better facility in life, better start in life, and they are always in a higher upper position than a better position that of an ordinary person, or a person who are not able to compete with others. So we call it the educationally backward person who should be given a benefit in the matter of public environment or educational admission to educational institutions or reservation in educational institutions. It is so provided. So also the economically backward persons. Economically backward persons, we know, after celebrated Supreme Court judgment in Sasidharan, what is provided is that persons having the creamy layer will not be entitled for the benefit of reservation, except person belonging to scheduled caste or scheduled tribe. Now that issue is being concluded to Supreme Court High Court, whether SC/ST candidate should be given the benefit even in spite of the fact that they belong to creamy layer or not. Creamy layer, an income ceiling is fixed for seeking reservation for public environment. That income ceiling, you should produce a certificate saying that this man's income, this family income is less than 5 lakhs or 4 lakhs, whatever it may be, and that they will be given the reservation for that. In fact, in the matter of education, that is originally the income limit or reservation until commission report was extended only to the creamy layer and non-creamy layer among the backward community candidates. That created an inequality among persons who are not otherwise entitled for reservation, who belongs to upper class of community. Then the Supreme Court said that, so the Constitution said, you can make a reservation in favor of persons who are economically backward. So that is to say, a person who is not enjoying the benefit of reservation in any other form, whether it is community reservation or otherwise, will be entitled for reservation in the matter of public employment or admission to colleges, education institutions, etc., if they belong to economically backward community. So reservations are different types of all groups of persons in the society are given a protection so as to bring in an equality in the society. The egalitarian society is one to be maintained and protected, and our endeavor, effort should be to maintain equality from all the persons. How it can be brought in is the question which was posed before the framers of the Constitution. Framers of the Constitution first of all took the matter, saying that public employment, they should be given equal opportunity. So they should be given a protective discrimination. Educational institutions, they should be given a protective discrimination in the matter of their admission to the colleges. Then, of late, 21st century this issue came, saying that there are other group of persons who may be born in a higher community, higher caste, but they are not getting any benefit of reservation. What should be dealt with them? Then they said, no, you should provide a benefit of economically backward persons also. A benefit should be provided so that all sections of the society are benefited by the reservation principle. So that is the basic principle of reservation provided under Article 15, 16, 19 or 365 of the Constitution of India. Our effort should be to bring in all persons, 335 deals with special benefit guaranteed to SC/ST persons. So what I am saying is to put it consistent with the maintenance of efficiency of administration. Reservation is provided. Reservation is provided not to give employment to the person they don't know, public employment no. That is not the concept, basic concept. Subject to the efficiency of administration, you should provide them some avenues even by relaxing the standard fixed for other community candidates or other forward community candidates. Then, as I said earlier, saying that all this should be a race between equals and not with unequals. The crippled horse and their resource. The crippled horse should be given additional advantage to compete with a resource. So, what is protected? That doesn't mean that you should ignore the efficiency of administration. So, merit should be profit sacrificed. No, that never said. Subject to the efficiency of administration, and the reservation should be provided to the candidate. They may, so how it can be implemented? Suppose for a selection, a minimum cut-off mark will be prescribed for forward community candidates, because the number of applicants will be large and the post vacant will be less. How to choose these among these persons? You may screen the persons by conducting a screening test, that is shortlisting them, and also conducting an interview defined as a merit list, etc. For that, you may fix a standard or minimum cut-off mark for being included either in shortlist or in the final rank list. But in relation to the person with reservations, a lower cut-off mark can be fixed. Suppose 50 is the minimum cut-off mark for candidates possessing candidate who belongs to forward community, then you can reduce it to 30 or 35, whatever it may be, subject to deficiency. No, don't make it 0, don't make it 10, don't make it 20, whatever it may be. But subject to efficiency of administration, you reduce the cut-off mark so that they will also get an opportunity to compete for the selections in the service of society. So that is the general thing. Then generally we call it two types of reservation as provided under the Constitution. One is vertical reservation, other is horizontal reservation. Vertical reservation is so simple. So Supreme Court uses the words vertical reservation, horizontal reservation, etc. make it complicated so that normally ordinary man will not understand it at the glance. It is so simple. Vertical reservation is a reservation in favor of scheduled caste and other backward community candidates. So communal reservation provided under the Constitution is called as vertical reservation. It is not at all a complicated term. Vertical reservation is provided for persons belonging to persons of community, different communities. Other is horizontal reservation. Horizontal reservation is in favor of the physically challenged persons and like. That is to say that in the vertical reservation, we provide communal reservation to various communities in their order as provided in the rules. Horizontal reservation, there is no further reservation. You just horizontally, you make a reservation in favor of PWD candidate, for example, this person with disability. For person, vacancies are reserved for person with disability. That we call that horizontal reservation. In that there is no further reservation except to the extent of providing reservation to each group of persons. Each group of persons is first 4 persons reserved. That is in the order of blind, deaf, ortho, and now cerebral palsy, etc. last year. The reservation provided is in relation to the turn by the central government. Central government say originally it was the 25th turn which was provided for reservation and for 52, etc., etc. But Supreme Court now says reservation to be to 1, 26, just like that, done like that. 4 posts out of the 100 posts. That is horizontal reservation. And what happens if a person belonging to a particular group of persons is not available? Our rules say that can be passed over to the next candidate who is suffering from the same disability. Same disability, ortho candidates are not available, blind is not available, then it will go to ortho. Ortho candidate also not available, it will go to, deaf will go to the persons, deaf is not also not available, it will go to ortho. Ortho is also not available, it will go to the cerebral palsy. This is the rule. Otherwise, in relation to the communal reservation, what we say, a fixed percentage of posts or vacancies are reserved for the person belonging to a particular community. Fixed percentage of the vacancies in a data. That is provided with. As far as our rule is concerned, we make special reservation in favor of different communities in Rule 5. Rule 5 will say that out of 100 terms, Annexure 1 of our rules, which say that the persons belonging to each community is provided with the reservations as contemplated, percentage reservation as contemplated. Our Rule 5 say there shall be vertical reservation, that is communal reservation, of 10% for, don't misunderstand, I may spell the community in which I pronounce it now, Bhutia and Lecha, and 7% scheduled tribe, 3 to scheduled caste, 10 to other backward classes, and 10% to other backward classes state list and central list, 3 for primitive tribes, and 2 for other backward list, and 1 for the economically weaker section. So, each community is provided with a percentage in a 100% roster. The roster is 100%. Each community is provided with a percentage of vacancies. How it is to be provided with the next question. Then our would say that the reservation should be in the order in which it is provided in Annexure 1. Annexure 1 say that how it is to be worked out. We cannot simply give one goes to other and etc. No. There should be an order in which the reservation is to be provided with. Our will say the first vacancy should go to differently abled person. That is a central rule. We cannot change it, central notification. Then the question comes, second vacancy comes, to whom it should be provided. There is a basic principle, cardinal rule, saying that reservation shall not exceed 50%. Out of the vacancies available for filling up, in no year, reservation shall exceed 50%. To put it otherwise, if there is 2 vacancies available, then 1:1 can be provided with. If there is 3 vacancies available, then 2 will go to open competition candidates and 1 will go to the reservation community candidates. Here the roster of cycle is a continuous roster. Continuous roster means it starts from 1, ends with 100, again it is repeated. It is a running or continuing rotation, and it is not confined to a particular year. It is not confined to a particular selection. It runs like that. Suppose there is 10 vacancies available with the administration. How it is to be apportioned? It is to be apportioned in the ratio of 5:5. 5 open competition and 5 will go to reservation. If there is 11 vacancies, 6:5 should be the ratio. Then yet another cardinal principle is that a person included in the rank list, if he belongs to a backward community, he is entitled for the benefit in both the world. To put it otherwise, he is entitled for the benefit of the open competition merit, so also the reservation benefit. If the turn comes is that of an open competition candidate, you cannot say that you are accommodated, adjusted towards the reservation candidate. Then the direct casualty, direct consequence will be that a reservation candidate otherwise entitled to will lose their chance of selection. So they are entitled for both the world. So what we generally does is that if about 5 vacancies, 10 vacancies are available with that institution, you find out vacancies are apportioned in the ratio of 5:5. 5 go to open competition, 5 go to the reservation ability candidate. Okay. Then, how to select the first 5 open competition candidates? Irrespective of the community, that is on the right hand side, rank number 1 to 5 should be selected first. Then they should be assigned the serial number going by our roster, saying that 2 will go to open competition, then 4 go to open competition, 6 go to open competition, and 8 goes to open competition, and 10 goes to open competition. Rank number 1 to 5 should be at the first stage be assigned the serial numbers 2, 4, 6, 8 and 10. Right, rank number 1, the name will be there, his position, his rank number is there, name is there, and his position in the rotation is also there, 2, 4, 6, etc., etc. Then what we have to do, these 10 persons are now gone out of the list. Then we take the reservation terms. Then we, out of 5 persons already gone, open competition candidates. Then we take who is the next Gutiya candidates, furniture candidates, both are grouped together. Then he will be assigned the rank number 3 in the list, in the first chance. I think I make so clear now. Suppose there is 10 vacancy, 5 vacancy for open competition, 5 vacancy for merit candidates. Then we have to do is, the first vacancy will go to the different labeled persons. The vacancy available for apportionment as far as first list is concerned is 9. We will apportion it to 5:4. 5 persons on merit should be selected first. They are filled up in the turns. If turn is there, 2, 4, 6, 7 and 10. For turn they fill it up with the first candidate, 1 to 5 candidates. Then the remaining candidates in the list, we will look into who is the next candidate belonging to Bhutia and Lecha. He will be assigned the turn 3. Then next turn we will give it to remaining candidates in the scheduled caste. Then the 7th turn we will go to OBC central list. 9th turn we will give it to OBC state list. That is to say, a candidate, suppose the first rank holder belong to Bhutia Lecha, or second rank holder belong to Bhutia Lecha, community will not lose their turn, because that man is entitled, that candidate is entitled for reservation on the open competition terms. He need not go for reservation at all. I can say, proudly say, I am selected, otherwise I wouldn't say it otherwise, I am selected open competition candidate. I came on merit. He can write it. And also that the community will not lose, because all the candidates, all the first rank holders are Bhutia Lecha, for example. Then all of them selected, 1, 2, 3 for continuous rotation, we work out like that. Then many will go to, the second vacancy will go to Bhutia Lecha, third vacancy will go to, fourth vacancy will go to scheduled tribe, 7 will go to OBC central list, etc. If that being so, the merit candidates will lose their chance, one thing. So also the candidates belonging to the community to which that candidate belongs will also lose their chance to have an equal representation based on the reservation principles. That is, on reservation principle, you say that you initial entry, we makes it clear saying that the open competition merit candidate belongs to a separate class. Reservation candidate another class of persons. Then we work out this. What we will do is we will fill up the second turn by first rank holder, fourth turn by second rank holder, keeping the third position open sense vacant. Then we go to the sixth candidate, keeping the fifth turn open, kept aside, and like that. And remaining candidates in the list, we fill it up by taking persons in the bottom of the list. There may be person who is in the bottom of the list, but is entitled for the benefit of reservation, because there should be adequate and sufficient representation for persons belonging to a particular community is the mandate of the rules. Reservation not on merit alone, no. They are entitled for the benefit of both the world. If you can compete, a community candidate can very well say, I am not competing for any community benefit. I contest for open competition and I win the. Sometimes he can see, or he may benefit without of that. So what I am saying is, this principle of reservation working out rotation is simple in that sense. You just take a pen and pencil and the rank list in one hand and put who are the rank holders, etc. Then find out how many vacancies are there. Suppose 10 vacancies are there. Apportion the vacancy into 5:5. Okay. Then first 5 candidates, irrespective of the immunity, assign them that open competition term first. That may be that you can say 8, 10, 12, 14, etc. Open competition, you fill it up. Then find out who are the remaining candidates in the rank list, who otherwise entitled for reservation, in turns in tune with that of the roster which we had mandated under the rules. So we say, this is obvious, that is, who is the candidate, who will be given that, who is less than that, who put up with that. Just a mathematical correction. Just a matter of obedience. Simple. So simple. But the consequence of working out rotation like that makes an ocean of difference. If we give all the five candidates, 10 candidates according to the reservations, then there won't be any adequate sufficient representation in the service. And the person who gets the benefit of reservation otherwise would have been gone to the merit list, and the merit list would have been gone to a community candidate, etc. And insofar as the candidates are concerned, it may have a very drastic consequences in its application. What I am saying is, the benefit of reservation is in favor of a community. The candidates are only beneficiaries of that reservation. Candidates are only beneficiaries. Community is granted the benefit of reservation. That community should get the full extent of the reservation provided in the rules, if only the person who otherwise entitled to get selected and appointed based on merit are excluded from the purview of reservation, because these persons are entitled for the benefit of both the world. This is a singular proposition. Then we say regarding the PWD candidates. PWD candidates I brought your notice saying that this is a horizontal reservation. That the term that should be provided in the rules should be given to them. And how it is to be taken. The reservation provided to the PWD candidates is not a vertical reservation but only a horizontal reservation. So that should be taken out of the communal reservation provided under the rules or under Rule 5 of our rules or the annexure thereof. You cannot mix both together. You cannot take away one turn of either backward community or open competition candidate and give it to PWD candidate. No, that you cannot do. You have to work out, you have to maintain a separate register for that. A separate register is maintained, and that when the vacancy or turn arises of a person belonging to a physically challenged group, then that should be allotted to them. Only vacancy goes and not the turns. In our rules, what is provided is the turns. Each community is having, open competition community is having its own turns. PW hands are concerned, they are not taking away any of the turns of any of the community. They stand independently. That is all vertical, horizontal reservations. So we have to maintain a separate roster for the person belonging to the physically challenged persons and work out the ratio in terms of the vacancy position that is available to us. That is 127, etc., etc., 52, etc. So that is 66, 87. So what I am saying is the reservation principle is founded on a larger constitutional philosophy, that is equality in the society, equal protection of law in the society, and to bring in a society in which all are given sufficient opportunity to come up in the social life, come up in the economic life, come up in the educational sphere. So that is the basic intention of this reservation provided as of now under the Constitution of India. This is all what we can say of generally about the reservation principle, etc. So in our rule is concerned, we had provided how the turn has to be fixed. The turn are fixed based on the different concept altogether, in the sense that may be depend upon the availability, the number of persons representing a particular community in the state, in the civil service. One aspect of the matter. Secondly, the adequacy or otherwise of the representation is taken into consideration in relation to the population. What is the number of population in the state? What is the representative? What is how many persons are represented in the state belongs to that group of persons? One aspect of the matter which we generally take into consideration. For generally saying, for children we say 10% reservation is constitutionally provided with. Others are only an enabling provision in the Constitution. State can make law for providing reservation. It is not as if it is mandated that reservation is the rule. No. Reservation is only an exception. An exception to the general rule. Exception to the general rule, and the reservation is only enabled by the Constitution or the statutory law made by the government in that regard. So reservation, the adequacy of representation, sufficiency of the representation, etc. are the prime consideration of the reservation in favor of a particular, fixing the percentage of persons to be represented in the state civil service. But that is not a constant factor. Suppose reservation is provided with and persons are overrepresented of a particular community. Certainly, state is enabled to reclassify the percentage of reservation provided, and they can provide a lesser reservation or to give more reservation to a particular community who is not properly represented. All this can be done by the state, but how it is particularly possible is something different. So what I am saying is, generally saying, our Constitution protects and preserves the right of persons who are downtrodden, who needs help at the hands of the state, who needs help at the hands of the society, who needs help at the hands of persons who are otherwise in a better position than the others. you also come with me. I'll bring you up. This is the basic principle of law which we initiated by providing reservation for public employment, even in spite of the fact that Article 16 say or 14 say all are equal before law, equal protection should be given. Public employment, nobody can be discriminated. Right of public employment is a right, say Article 19, etc. Even then, those are the fundamental right. So even though it says the Constitution provides that a reasonable restrictions, in consonance with the preamble of the Constitution of India and in tune with the directive principles which gain the policies of the government in the matter of administration of the society. Generally, this is the thing. Now you can, I think, reasonably explained. Then you can ask questions. We can interact.
So, I have a small query.
No.
If in a certain year the vacancy which is arisen is only one, how would the roster operate?
Yeah.
How would this
Only one vacancy.
Yes.
One vacancy, there is no reservation.
No reservation.
Then what happened is, two things arises now. Single cadre post, there is no reservation. General principle, single cadre, no reservation. Secondly, there is plurality of posts in a service. But in a selection year, only one vacancy arises. Rotation is continuous. Rotation sometimes may end with about 16 OC. Then the next turn is that of 17 AC. How can you work it out? Then generally we say what is to be done is you should temporarily pass over the 17th turn to maintain 50% rule. 50% rule is no year selection shall not exceed 50%. So in the roster we will make an endorsement saying that the turn of 17 is temporarily pass over. You can use the abbreviation TPO to keep the 50% rule. But if say on the same selection year another vacancy arises, certainly you can compensate or you can fill up the 17th term at the first instance. then alone you should go to the second term. So even if a term ends in the previous election with an OC term and the present selection is to start with a backward community term, the backward community term cannot be filled up because at no point of time, I may say even a split of second, you cannot violate 50% rule. You cannot expect that another vacancy may come or may not come. That is different. For a split of seconds, you cannot violate the 50% rule. So, always, if there is only first vacancy, that should go to an open competition candidate. One thing. Secondly, if 3 vacancies are reported, we apportion it in the tune of turn of 2:1, ratio of 2:1. Then what should be done? How that vacancy is to be filled up. Take here example itself now. Suppose the turn ends with, previously ended with the 10th OBC, 8th OBC, 8th open competition. The next turn is to be filled up with OBC. Then 10 open competition, 11 with their HR. Then open competition. So how we have to fill it up, of course? Only one vacancy can be filled up by backward community candidate. No doubt on that. No doubt. Otherwise, it may violate 50% rule. Okay. Even then, who should be selected first? The immediate question. Because going by the roster, it will go to a reservation community. And next 2 turns, if you can fill it up, open competition candidate, then there won't be a total violation of 50% rule, because 1:2 is the ratio we follow. But you cannot follow the ratio 1:2, because the moment you fill up the post by a reservation candidate, first instance, there will be one split, maybe a split of comment. 10-15 you may fill up the post by a reservation community candidate, 10-20 by an OC candidate. Even then, the rule, 50% rule is violated. 50% rule is violated because all the first turns should be filled up by open competition candidate. Otherwise, the difficulty will be that the next candidate will be sometimes a reservation community candidate, first rank holder candidate. If he is given the reservation, then otherwise he is entitled for open competition. That turn is lost. That turn to that community is lost, because otherwise he will get an open competition. They will get a representation for 2 persons. That you are now defeating it. So, if 3 vacancies are there, what you should do is that fill up the next 2 OC terms first by rank number 1 and 2. Then the turn between, that is the team, be filled up any candidate below 2. After exhaustion 1 and 2, 3 or 4, anybody belong to that community. So open competition candidate, the first rank holder will be sometimes the first rank holder may be the reservation community candidate. Sometimes he belongs to same community to which the turn itself has risen. If you will have that post by rank number 1, because the reservation community turn, he may not have adversely affected, but the reservation provided for the community is affected, because they will get the benefit of both the world, open competition world and the merit world, so also the reservation world. So first rank holder will get in merit, second rank holder should get it on reservation. So community will get 2 turns. That is the basic principles of reservation. That is saying that they are entitled for both the world, and by reservation you cannot defeat the right of the community to get a candidate selected based on merit. So if 3 vacancies are available and rotation is to start from the reservation community, because it is a continuous rotation. It is a continuous rotation. Where it stopped previous year, we start by this year. Then what we should do is, we should fill up the next 2 OC candidates first with rank number 1 and 2, and fill up the return, the first which arises by a reservation community candidate by a rank holder who is below 2. The 3 or afterwards that community belongs to that. Sometimes, as I said earlier, the first rank holder may be the same community person, but he is entitled for turn of merit turn. Otherwise it will be, in practical sense, it will be defeated. Theoretically also it will be defeated. You cannot in fact defeat a right of reservation in an indirect manner, which is directly provided, saying that Constitution Supreme Court said they are entitled for both the world, only because the candidates are selected on merit quota, you cannot, reservation quota, you cannot reduce that reservation quota, that candidate's quota from the reservation quota, that merit candidate's quota, community from the reservation quota. That is a well-established principle. So this is the way in which you do. So always fill up in a selection year. 50% rule shall not be violated is the principle. And suppose same selection year, the 4th vacancy comes. Certainly you can fill it up by the community candidate, because reservation is not violated. Karam 2:2, rotation ratio will be 2:2, that's not difficulty. But if there is 5 vacancy comes, then it will be 3:2. Again, one vacancy goes and other 2 vacancies go to other person. That's all, just like a mathematical procedure, just to be upfront, that's all. Not that much complicated and all these things. But if you explain it by words, it may be complicated. But if you work out in practical sense, it will be so easy. Just put it here and there. So keep in mind, always keep in mind, 50% rule is the mandate of the Constitution. No certain here, you shall exceed 50%. Secondly, a candidate belonging to the community candidate is entitled for the benefit of both the world, that is reservation as well as merit. If it turn otherwise arises on merit turn, certainly he should be granted that benefit. And that shall not be defeated.
Sir, I just have a question. Like, the Sikkim Judicial Academy is a very small institute with barely 30 to 40 employees at present. So we have specific cadres, like for instance, we have the stenographer cadre. So we have only 2 posts there. One is a stenographer grade 3, then there's a promotion post of stenographer grade 2. Both the posts have only 1 vacancy, one post each. So now in this case, for instance, we have advertised, let's say, for stenographer grade 3. Only 1 post, it goes unreserved, correct? And then we wait for the stenographer grade 3 to be promoted as grade 2. Then after 5 years, there is another vacancy that comes. So now, does the reservation apply in the subsequent vacancy after 5 years?
No. One thing, ma'am. Reservation is basically intended for direct recruitment.
It's a direct recruitment.
Unless it is specifically provided in the Constitution or in the rules saying that reservation applies to promotion as well. Constitution now provides that you can make revenues for promotion in favor of backward community candidates or PWD candidates as well for the purpose of promotion. If the rules enables a quota, a percentage of posts, you say there are 2 sources. One is by promotion, by other by 2 sources. So, in which source the reservation is to be provided with, then you can make a provision for that. Suppose you put a question saying that there is only 2 posts, that is in the cadre stand. You refer to cadre stand. Cadre stand is only 2. Suppose reservation is made applicable. One and a person promotion reservation is made applicable. A person is promoted. After 6 months he resigns or he left. He got other avenues. He got other source of promotions, or deputation, whatever. Then a second vacancy arises. For second vacancy you can say reservation is there because 40% rule is not violated. In any year, 50% rule shall not be violated, that is the rule. The rotation, the issue is not in relation to the cadre strength alone. Cadre strength basically that is there. If there is only 1 post in a cadre, you cannot make it. In the case, as you said, there is 2 posts at least.
No.
2 posts are there, one is for promotion, other is for.
But the vacancy in Steno 3 arises only after 5 years, after the Steno 3 gets promoted. So after 5 years, there is again a single vacancy. So will the reservation apply there?
No, it will not apply. And another thing is that the reservation is made available in the rules for direct recruitment or in the case of promotion as well. It cannot be. 5 years, no. 5 years, no. But you can say the reservation is made applicable, request him to take a leave, away leave. I provide you your salary and all these things. You sit in your house so that I can get a promotion. Then you come after some time. That is the solution. If 5 years, no, then you won't get it. Only 1 year. Selection year assumes great importance. Selection year generally means the date from which a rank list is published for direct recruitment is the next year same date. But the 20th is the day of the next 20th of 19th of August next year. That is the selection year we call it, not the January of the year in which selection was notified. Sometimes you will say your rule is not specifically not shown. Otherwise, generally we say that 1st January to December 31st, or the date on which the rank list was published in the selection.
So if somebody from reservation has got the job, somebody in reserve category has got the job, after 1 year he resigns, we have to re-advertise the post. The same reservation of the particular quota will not apply, the particular community will apply. It has to move forward to the other group after that.
That two things come back. Suppose there is only one vacancy notified. It is not mandated that your selection or rank list should contain only one candidate. You can include more than one candidate in that rank list. Generally, Supreme Court say 1:5 is the ratio to be followed. First one may not join. So then again you have to go to the honorary task of preparing a certificate, notification, etc. Second time also we get it. If within a period of 1 year, if the first rank voter leaves, certainly then you can say that that post should be filled up for the same rank list, for the same selection year, by applying the rules of reservation. If reservation is provided in the rules for such recruitment.
Within a year.
One thing that is specifically emphasized that if it is so provided in the rules. Generally, for direct recruitment higher post, if there is a one post, generally it is not provided with.
If you could kindly suggest, if there is an institute wherein we have a very small cadre and the vacancies which arises is only one, probably this year, then after 5 years, as Madam said, then after 5 years, is it advisable for us to have this reservation?
No, that is what I say. Reservation cannot be claimed as a matter of right. The general rule is that all should be given equal opportunity for public employment. Reservation is provided as an exception to the general rules. That is to say, by way of a legislation, by way of a law, you can make reservation. So you cannot say that since reservation is not provided with, or the getting a reservation is only a remote chance, why can't you provide it for now? I say you cannot compel to make reservation or provision for reservation, because constitutional mandate, it is only an enabling provision. You cannot mandate that. General rule is that as a law, as the general law, equality for public employment is the law, and all should be treated equally. No doubt about it. So you cannot say that. You may feel hardship. In that sense, some other group of persons will get a accelerated promotion or something like that. If you don't, that is all chance and luck in life, not otherwise. So you cannot take it.
Yeah.
Hello, sir. So supposing a person, supposing the Constitution under Article 16, it says that the state, if it feels that a class or a section of people have been underrepresented, sir, so the state can, to uplift them, can reserve some post for them, isn't it, sir? So, sir, supposing a community has been given reservation for a long span of time, sir, after that the state feels now they have reached some mark that they don't need representation from now on. Sir, can the state do that, sir?
Certainly, because as I stated earlier, reservation is made in favor of a community of candidates who are not adequately represented in the affairs of the state. The stress is on the word adequately represented. This also Supreme Court just said it. So whether there is adequate representation or not, periodical review of the strength of the representation of the community candidates in a list, in a service, can be taken note of. It need not be confined to, to reservation candidate who come to service solely based on reservation rule. No. It can be what is the strength of the service, character strength of the service. What is the representation for each community? Whether there may be then, if a community is given 10% reservation, for example, other community is given only 3% reservation, they may not be equal, adequately represented. 3% will not be adequately represented, and they are not likely to be adequately represented in any near future. Whereas the 10% will be represented always at the upper limit. No? Sometimes. So what we say is, adequately represented or not is a matter to be looked into. Can be, the government can certainly change the percentage of reservation provided in the rules. But the practical regime, as we had noted in larger number of the issues, social issues, saying that may not, once it is provided, may not be that much easy to take it away.
So supposing the state feels that for this time you won't be giving vertical reservation, will be only giving horizontal reservation. So can they do that?
That is enough. There is two concepts altogether. That is all. Vertical reservation is the communal reservation. State can take away the reservation also. No doubt about it. But the social ramification or political unrest, these are all matters which now state will be able to do it in the present day context. You can take out certain posts from the reservation. As I stated, Dr. Notice saying that depending upon the administrative efficiency. Administrative efficiency, you can take away certain posts from the public. That is something different. But you can totally take away the reservation because Constitution says that state should endeavor, because a egalitarian society is yet to be established, yet to come into force. There is social, economic and backwardness in India. You cannot rule it out at all. You cannot rule educational backwardness is there, social backwardness is there. All respect there is backwardness and inequality. So that is, even after 80 years, we are not able to cope up the thing. The population is increasing and possible. But depends upon the geographical situation of each state. So the moment I saw the reservation provided in our state, the reservation provided is 10% for scheduled caste, 2% for scheduled tribe, and 10% for backward community candidates, etc. Muslim reservation is about the 12%, etc. is provided. In our state, it is not the case. It is something different. That depends upon the representation of the community in the state with reference to their population. Then only you get a motivation for acquiring higher qualification, studying, etc. And we give a public employment to one man, that entire family will be brought to a different level. Next generation will be get a better education, better living standard. But so many things are. This is the only way out to bring it up so-called socialist pattern of society. One way of doing it. And yes, take PWD, person with disability. As I brought your notice saying that the turn 1, 26, 51 and 76 are the 4 terms reserved for person with a disability. 1, 26, 51 and 76. One thing to be remembered is that reservation in favor of person with disability is also not as a matter of right. The government is enabled to identify the posts suitable for appointment of person with disability. To put it otherwise, the first and foremost thing under the PWA Act is that there should be an identification of the posts. If the posts are identified, identification of a post depends upon the functional parity of that post. You cannot say that a driver should be appointed with a person with orthopedic disability, or a telephone operator be appointed a person with deafness. So that's all simple illustration. So to put it, so we'll say that identification of the post with the functional parity of the post is very relevant. So also presently, reservation is also provided for promotion of person with disability. For that also, a assessment or a post, the post should be identified by the government. So to claim the benefit of reservation under the PWA Act, it is mandatory that the post should be first identified. If the post is so identified by the government, then reservation in the post should be identified with reference to the disability of a person. A person may be found fit to be appointed with the disability of orthopedic disability or other disabilities or deafness or for that matter blindness. But he may not be able to or suitable to be appointed to another post with a disability. So depending upon the ability of a person to discharge his functions and duties with reference to the post to which he is working or attached, that is the most relevant aspect of the matter. So the government or appointing authority, the High Court is concerned, we are the appointing authority. High Court is concerned, we are to identify the post, whether this post is fit for appointment or a person appointed with that physical disability will be able to discharge the functions and duties of the post or duties attached to the post. So also for promotion, that is the important aspect of the matter. Secondly, as I brought your notice, it is only a horizontal reservation, not a vertical reservation. Since it is a horizontal reservation, that will not be, this identified post, a 4% reservation, is not one to be included in the 100-point roster. 100-point roster we follow in relation to the vertical reservations and the open competition candidate. That is 50% rule, etc., etc. The 50% rule is not applicable to the horizontal reservations. That is to say, if only there is one post, even then, going by the notification issued by central government or under the PWA Act, the post should be filled up by person with disability, because 50% rule has no application in such cases, is the law. Otherwise, the horizontal, being a horizontal reservation, you cannot say that since there is only one post, reservation cannot be made applicable, or if reservation is made, then it will exceed the 50% rule. You cannot see it. And it is taken out of the 100% roster as well. It is an out-of-turn reservation provided in favor of a group of persons. having the disabilities. So what we should do is that when a first term is filled up, we fill up that term with the person with disability that is not reduced either from open competition terms or from the backward community terms. A separate roster, separate register is to be maintained for that. It is only the vacancies which are filled up, not the terms. There is a ocean of difference between the vacancy and the term. Term is provided in the underpoint roster. First term will go to the community, second term goes to the community, etc. Other thing we will say is that the post is reserved, vacancy is reserved, not the terms. So 4 vacancies are reserved for physically challenged persons, which is to be filled up in the order in which it is provided under the PW Act, that too in relation to the post identified by the government in that regard. The communal reservation is provided only for the candidate in favor of vertical reservation. And that I may say, suggest saying that while applying the ratio or reservation provided for PW candidate, a separate register be maintained and find out what is the turn which is, what is the vacancy which is recent to be filled up in accordance with the rules. The vacancy is the first vacancy, or 21st vacancy, 26th vacancy, 22, 76, etc. that is given and taken out of the main rotation which we follow. Otherwise, the difficulty will be that it may adversely affect the 50% rule, the reservation provided in favor of a particular community, reservation provided in accordance with the constitutional provision, that is the thing. But that is always subject to the identification. So also by promotion also, same principle applies. If the posts are identified by the government for the purpose of filling up by reservation, then reservation principle is to be followed. It's the general principle in that regard. I think that position. You got any doubt on regarding working out of that? The questions. Proceed further with that. Got it? Okay. Then the next issue is in relation to the filling of the posts when there is no plurality of posts, which I said, saying that if there is only one post, you should fill it by 50% rule or open competition and then pass over and do it later. That is something different. Then restoration provided, I said submitted, as I brought your notice saying that it is always left to government to re-notify the post, re-adjust the post, etc., etc., etc. And a special provision can also be made saying for special recruitment. That is to say, we follow a reservation terms, we follow a pattern of reservation in favor of a community candidate, open competition, etc., etc., etc. Suppose ultimately we find that a community is not, even after the reservation provided, it has not been adequately represented, what should be done? The rule-making authority can make a provision for special recruitment in favor of candidates, in favor of a community who are not adequately represented in the state services. If a person is not adequately represented in the state services, certainly a special recruitment in favor of them from among those candidates can be made, which is also constitutionally permissible in accordance with law. And there is no legal bar as such in that. But all these things should be done only based on a study, data, materials, policy decision, which is in consonance with the constitutional principle without adversely affecting the rights of the rights or privileges of other persons. That part. A question was put to me in relation to a physically challenged person for reservation, so also a reservation in the general category. General means merit candidate or reservation community candidate. To which category he should be first accommodated. Two things arises there. One thing, selection is generally from among the applicants. From among the applicants, you find out the most suitable candidates for the employment, for the purpose. So, most suitable candidates, if you find, and you rank them in the basis of the ranking merit obtained by them in the selection process. So, if one candidate is included in both the list, in the merit list published along with that, or in the PWD list, or if it is included only in the PWD list, then what will be the consequences? If it is included in both the lists, that is merit list, we said that for reservation otherwise, maybe, and also PWD list. Secondly, that it can be offered appointment with reference to the time at which, point of time at which the first vacancy arises. That is, if the vacancy arises in the first turn, merit list first, then he can be offered with appointment. Or if the turn arises in the PWD list, he can be appointed to that. There is no difficulty of that. Suppose he is included only in the PWD list, he cannot be offered with appointment in the general list at all. General list at all. And that only thing is that only if a candidate applies to a post pursuant to a notification, then alone he can be included in the list. Suppose a notification is issued, common notification is issued, both for PWD and general recruitment. A candidate is opted only for general recruitment and not for PWD. Then he can be included only in the general candidate. I can forfeit my claim of a PWD candidate. Same with a PWD candidate opting only PWD, not a general candidate. Then he can give only that. Suppose I may get a better marks in the recruitment process. In the PWD I may get about 60 marks. Person with the 50 marks will be get a better chance of appointing in the general list. You may get it, that you cannot find fault with that. Because you have to compete among the candidates competing for selection. Because selection always involves a selection of best suitable candidates from among themselves. From among themselves assumes very important. You may be a big man, but if you are not competing along with others, you cannot be said that and a better candidate will be selected. That is the view you see. Then regarding the PWD candidates, carrying forward theory. Carrying forward theory generally applies for central government notifications. If a candidate belongs to a particular community candidate not available, you have to select them in the next succeeding selection year, keeping that vacancy unfilled. But as far as our rule is concerned, we are unable to give it to the next available candidate with other physical disability. Maybe because, like you said, that was the old rule that needs a slight modification. 36 of the PWD Act saying vacancies not to be filled up, to be carried forward. For in any recruitment year, any vacancy under section 33 cannot be filled up due to non-availability of suitable person with disability or other sufficient reason. Such vacancy shall be carried forward in the succeeding recruitment year. And if in succeeding recruitment year also suitable persons are not available, it may be first be filled up by interchange among three candidates, and only when there is a person with disability, the employer shall fill up the vacancy appointing a person without any disability. But our rule is slightly different. Old rules say if a particular disability person is not available, then you can fill it up same selection year yet by another person with the disability. Suppose blind persons are not available, then you can go to deaf. If deaf is not available, then you can go to ortho. The ortho is not available, you go to civil person. That is also the old rule. But this 35 was amended, and a slight modification may be necessary. It's noticed by me. Anyway, as long as there is no challenge against that, we bother about it. Our rules say, in case of unavailability of suitable candidates with same category of disability, it shall be filled up by interchange of among other candidates for disability. In case unavailability of candidates of any category of disability, the same shall be carried forward to three succeeding recruitment year, and finally it lapses. That close there is 4.
Hello sir, may I please ask one question? Good afternoon sir, my name is Dr. Tashupal Zulepcha. I am from Sikkim Judicial Academy. At the outset, I would like to express my sincere gratitude for being with us here today, and thank you for the insightful session. So my question is pertaining to the state of Sikkim. One of the factors of Sikkim's integration with the Union of India in the year 1975 was the social and economic upliftment of the people of Sikkim. And in the last 50 years of Sikkim's integration with India, there is reservation policies in Sikkim government service rules. And so far, the Sikkimese locals have been adequately represented in all sectors. But in Sikkim's subordinate judiciary, it's an open competitive examination. So in such circumstances, can the government of Sikkim prescribe reservation rules in subordinate judiciary? Or is there any other legal ways for us to ensure that reservation is also provided in Sikkim judiciary, in subordinate entry level?
Subordinate judiciary, certainly all other states reservation is provided with. All other states reservation is provided with. And if rule does not permit a reservation, it may not be possible to find out some other way out. No. Reservation can be provided in the rules, providing reservation for any community, just like what you had put in. But in the state rules, reservation is provided. Sometimes, maybe for the reason that to maintain the efficiency of the administration or judicial service, that reservation might have been taken out, or it is not been provided with. Maybe, sometimes. We don't know what is the policy of the government in that regard. But efficiency can never be, because you can always prescribe a standard. You need not say, suppose you say that return tax you should get 50%, 60% for open competition, merit candidate, 50% for reservation candidates. So that reservation is, that efficiency of service is not defeated. 50% is provided. Some relaxed standard can be provided with for conducting the selection. So also for favorite scheduled caste community candidate, etc. Some relaxed standard can be prescribed. With that relaxed standard, you can go for selection. Even if reservation is not provided with in the service, you can certainly give an opportunity to persons who are socially and economically backward to compete with the selection with others and to be included in the list and get appointment. Even if reservation is not provided at all, some relaxed standard can be followed.
Thank you, sir.
They are not always same rigor or standard in the matter of selection is not contemplated or mandated. Because the real difficulty is this. After law graduation, you may go for training in Delhi or somewhere else. And person may not be able to go to other centers for getting training, for coaching centers, etc. In Kerala, there is a large number of coaching centers. We don't know which it is available. Coaching centers may not be able to compete in the competitive examination. And also the nature of things, and also the general law. In fact, yesterday I was asking what is the nature of cases in the state. That is not a general state, you cannot find that much of litigation in property field, property rights, etc. That is not much available in the state, no. in our state now, transfer of property and all these things, civil procedure, litigation is going on like that. And yes, also commercial law may be limited cases will be there in the commercial field. Maybe criminal cases not of all types, only very few separate types of cases are there. So we will not be able to, even if you actually go to actual practice, you will not be well versed in all branches of law as a whole. You will be specializing in certain branches of law, that too in a special locality also, crime and everything may differ. So you should always fix it. And the question you put it in the examination will be general questions. Not confined to any branch of law, all branches of law you will touch. It may not be that much possible for a student, they can meet with all these things. So that a large standard should be provided with for person with disability and all these things, so that a less advantageous person in the society is also enabled to come up to the expected level of our constitutional makers. That's all what I see.